Good morning. Yes, call the list.
From daily cost list, under the heading orders with effect, serial number 1, MA 484 of 50, Mr. Bhasa Secretary, for the appellant, Mr. Nikhil Ranjan.
What are the defects?
There is one defect, authentication fee of rupees 10 on CC.
To remove the defect within 2 weeks.
Serial number 2, MA number 583 of 50. Ms. Tisha Thakur, Ms. Vandana Bharti, Mr. M. Jha, appellant.
What are the defects?
Partially removed, connection may be made, but the right to be used.
Defects to be removed within 3 weeks. One appears. No one appears. Only Jha appears.
Then the heading for order, serial number 3, MA number 115 of 50, with serial number 4, MA number 169 of 50. Mr. Pramod Kumar Chaudhary, Mr.
I appear for the appellant.
In the first case, Mr. D.P. Jha, appellant in the second case.
In serial number 3, I appear for the appellant.
Yes.
Lordship, there are two cases arising out of the same matter. 115 is filed by the claimants for enhancement, and another appeal, MA 169 2015, has been filed by the insurance company, Your Lordship, against the award, Your Lordship.
Yes.
In this case, Your Lordship, what happened in MA number, in both the cases, Your Lordship, the Moti Mineral Corporation is the a partnership firm, was the owner of the vehicle, Your Lordship. He died, and a petition under Order 22, Rule 10A has been filed by the party concerned, informing the court about the death of the person, and thereafter the partnership firm was 2 times reconstituted, and surviving partner's name has been given, Your Lordship.
They have appeared. Have they appeared?
In case Lordship 115, they have appeared by order dated 6/1/2021, Your Lordship. They were directed to file Wakalatnama, Your Lordship.
Lordship, we filed.
My Lord, in the first item, they have appeared by filing Wakalatnama, and in the second case, there was no such petition, my Lord, for the substitution of the surviving partners of the company concerned. Therefore, on the last occasion, the Honorable Court was of the view that this aspect will be seen under the appearance of the representative of the company, transport company, in the first appeal suffice for the purpose of second appeal or not.
So in the second case,
The insurance company didn't. They have not undertaken the exercise to implead the surviving partners.
Lordship, as per direction of the then bench, Your Lordship, a supplementary affidavit has been filed and informing the court about the same persons who has been impleaded in first case, Your Lordship. In para 5, I have filed it. That's why Your Lordship last occasion said that in both the cases the same persons are there. So let them up.
Who is appearing?
Lordship.
Who is appearing?
Your Lordship, on behalf of the respondent number 3 and 4, I am appearing.
So he will appear in the another case. Mr. Jha, you file a formal petition.
Lordship.
You file a formal petition.
Yes, Lordship, I will file. I will file it.
And mention in that petition that in the other case they have already appeared.
Yes, Lordship, I will file. I will file an IA, Lordship.
2 weeks time is granted to the appellant United, which company? Appellant National Insurance Company to file an appropriate application.
Yes, Lordship. Okay.
Serial number 5, MA number 185 of 50, Mr. S.J. Roy, for the appellant, Mr. Anvilal.
Lordship, I need 2 weeks time to file the requisites for the substitution and the new address that has notice has been to respond number 6.
2 weeks allowed on the request of the council for the petitioner appellant to take steps, appropriate steps.
Serial number 6, MA number 205 of 15. Mr.
My lords,
Abhay,
on behalf of my lords National Insurance Company, my lords, copy has been served to me, but I could not send it. But I was praying for 3 weeks time, my lords. I last indulgence. My lords.
What has
I'm
been,
sending-
why is
My lords, Oriental is the appellant, my lords. National is respondent number 4. On the last date, my lords, was pleased to direct them to serve copy to us. They have served it to me, my lords. But due to this corona situation, my lords,
who is appearing on behalf of the other respondents?
My lord, a notice has not been issued, my lord. Notice has been issued, my lord, but
4 and
the
6
year-
are one validly
Yes.
served. What about 2 and 3?
my lord, they did not contest it there also, my lord.
there is a report from CCR.
What is your ground, Mr. Mishra?
My lord, the ground is that the charge sheet has been submitted against the, my lord, respondent number 4. And also, my lord, the finding has been recorded against the respondent number 4, my lord, that there is no, my lord, negligence on the part of the, my lord, appellant, neither the owner nor the bus, my lord. So, my lord, the apportionment which was done 40 to 60%, that was long. When once finding has been recorded that there is no, my lord, negligence on the part of the appellant, insurance owner or bus, then, my lord, liability cannot be fastened. That too, my lord, the charge sheet has also been not filed, my lord, against this bus, my lord, driver and the
Yes, Mr. Manish Kumar, the liability, he says that the liability will be upon you.
yes, my lords, I have gone through the brief, my lords. It is a tough case for us. Therefore, I was saying, my lords, I could not hand over the copy.
Let me condone the delay.
Yes, my
Oblige,
lord.
Lord, sir.
Delay of how many days?
41 days, my lord.
41 days delay in filing this appeal. Counsel for the appellant submits that after the judgment was received, opinion was taken, legal opinion was sought for, and thereafter the file was sent to the office of the appellant, and approvals were taken from different level, resulting in delay of 41 days. Full stop. Considering his submission, I find that submission ground has been shown. Delay condoned. With this case, I'm heading for admission.
My lord, I am appealing for the respondent claimants, my lord, that is 5 to 7, my lords. I was saying that since there's the interstate dispute between two insurance companies, my lord, and this is a case of composite negligence.
Heading for admission.
My lords, I was only praying after 3 weeks लिखा दिया था, मैं कल ही आ जाएगा, नहीं तो फिर हम आज ही भेज रहे हैं, my lords. After 3 weeks लिखा दिया था, मैं.
Let this case under the heading for admission after 3 weeks.
Oblige, my lords, oblige.
Much obliged, your lord, sir.
Oblige.
MA 242 of 15. Mr. PC Sinha for the appellant.
Allowed. As Lordship, I am appearing, Lordship, for the appellant. Notice was issued to respondent number 1 and 2, who is respondent driver owner, Lordship. Owner and driver, that was depot. Notice was submitted on Lordship 8/12/21.
8/12.
हाँ हुजूर 8/12 को नोटिस फाइल किए हैं हुजूर. ऑर्डर हुआ था 29/11 को. किसी का अपीयरेंस नहीं दिखा रहा है हुजूर कॉज लिस्ट में, except the insurance company, Mr. Manish Kumar has appeared.
For enhancements,
As Lordship, but recovery right has been given, Lordship, to the insurance company.
recovery rate has been given.
insurance company have a right to recover all the paid compensation from the owner of the offending vehicle.
From the office server, from the process service report, I find that the notice has been validly served upon respondent number 1 and 2. Respondent number 1 and 2.
Yes, my lords.
Yes,
Owner
yes,
and
Lordship, yes.
Respondent number 1 and 2. Full stop. The notice is thus validly served. Full stop. List this case under the heading for admission.
Oblige, Lordship.
Serial number 8, MA number 264 of 15, Mr. Alok Lal, for the appellant, Mr. Ashish Singh, Mr. Ashok Kumar Yadav, Mr. Kumar Kumar for the respondent.
But in this case, the petition for deleting the name of respondent number 4 has been filed. The other heirs are already on record, Your Lordship. He seems to be the father of the deceased, Bipin Kumar Singh. So the other children and the wife of the deceased.
You want to delete whom?
Yes, Your Lordship.
You want to delete whom?
Respondent number 4, Nagdev Prasad Singh.
Who is he?
He was the father of the deceased, father-in-law of the respondent number 1, grandfather of the respondent 2 and 3, and husband of respondent number 5.
The deceased is Bipin Kumar Singh.
Yes, no, Nagdev Prasad Singh. Which deceased? Yes. Deceased was the victim was Nagdev Bipin Kumar Singh.
IA number 321 of 2022. This IA has been filed to delete the name of respondent number 4, Nagdev Prasad Singh, who is dead. Full stop. It has been submitted that all the heirs of Nagdev Prasad Singh are already on record. Thus, the name of respondent number 4 needs to be deleted. Full stop. Considering the aforesaid submission, the name of respondent number 4 be deleted from the cause title. The appellants would make the necessary correction in writing.
But that would not be possible in the COVID period, my lord. That would not be possible, Your Lordship.
It will be possible now.
I'm appearing for the respondents, Your Lordship, in this case, the claimants.
Serial number 9, MA number 358 of 15, Mr. Gautam Kumar, Mr. Sandeep Kumar Barnwal, Mr. Virat Kumar, Mr. Ravi Kumar Singh for the appellant, Naman Kumar Jha for the respondent.
Yes.
Yes, my lords, I'm appearing on behalf of the respondent in this case. My lords.
You are appearing on behalf of the respondents.
My lords.
So one day you remain absent, the other day the appellant remains absent. The case gets adjourned. It's very nice.
On the last previous occasion, my lords has directed us to decide कि ये लोग अगर it is a very meager amounts relating to 5,81,000 onwards, my lords, or he added.
So what is yours? It will be hardly 2,80,000, something like that.
My lords. तो हुजूर का वही डायरेक्शन था कि अपने पार्टी से इंस्ट्रक्शन ले लीजिए कि अल्टीमेटली वो भी चूंकि एक वाइफ हैं तो इसको 3 डिवीजन में डिसाइड कर दिया जाए तो हमारा इंस्ट्रक्शन यही है कि हुजूर का जैसा आदेश होगा वी हैव गॉट नो ऑब्जेक्शन
No. I have just asked that whether there was any chance for settlement or not. You tell me yes or no.
चूंकि there is my clients tried her level best to contact her, but that has not been possible, my lords.
Who tried level best to contact whom?
our clients, my lords.
Who is for
This
the appellant?
Mosma,
Who is for the appellant?
Mr. Gautam Kumar will argue, perhaps
Where is Mr. Gautam
Gautam.
Kumar? Mr. Gautam Kumar, Sandeep Kumar Barnwal, Anil Kumar Singh, where are they?
Well,
Where are they?
let it be adjourned for today, my lords.
No one appears on behalf of the appellant. This case is adjourned for 3 weeks.
Like, my lords.
Serial number 10, MA number 407 of 15, Mr. Alok Rao for the appellant.
Well, in this case, the notices were issued in terms of a direction dated 10th of December, but I do not know when the notices were filed. I'm not aware of the state of the notice, Your Worship.
Notice issued to respondent number 6 has been received by the wife. Full stop. The service is thus valid. Full stop. Next para. Fresh notice to respondent number 1 to 5. Correct and present address. Ordinary process to be filed within 5 weeks. Requisites to be filed within 5 weeks.
Serial number 12, MA number 519 of 15, Mr. Manish Kumar for the appellant.
What happened to 11?
Serial number 11 is wrongly listed. Notice has listed.
May I please, my lords?
Yes.
This case, my lords, notice was earlier issued, my lords, twice. But no one has appeared, my lords. It appears from the list. I am not aware whether it is validly served or not.
So they give a address which is incomplete.
My lords, the address has been given on the basis of their own claim petition itself, my lords. I'll verify, my lords, and again file requisite for correct address, my lords. Some time may be given, my lords.
What is your ground?
The ground is of permit, my lords. We have challenged because there is finding in our favor. The learned tribunal has held that permit was not valid on the date of accident. Even then, my lords, liability has been fastened upon us. If my lord will permit, I will show only one line, my lords. It has come, my lords, at
You take them. From the order dated 18/1/2020, passed in this case. Since the notice has been validly served upon the owner of the vehicle, that is respondent number 2. Let this case under the heading for admission. Full stop. Next para. It is not necessary to issue notice upon the claimants, as the insurance company is praying for recovering the amount of compensation from the owner of the vehicle. Admission. Get ready.
my lords, oblige me.
Serial number 13, MA number 523 of 15, Mr. Amit Kumar Das, Mr. Anjali Kumar, Mr. Jaspreet Mukherjee.
Lordship, in this case, notices were issued, Your Lordship.
So switch on your video.
My video is on, Your Lordship.
No. Switch on your video.
If Your Lordship permits, may I log out and log in from a different device, Your Lordship?
Yes. Log out and log in.
Am I visible now, Your Lordship? Am I visible now, Your Lordship?
Okay, what is just note down. Who is appearing for respondent number 1, 2, 3, and 5?
Yes, my lord.
You are appearing?
Yes,
Who is for?
for the claimants.
Who is for?
Oh. I am appearing for 1, 2, 3, 4, and 5, my lord. 4 is the claimant also, Kishan Kumar Mato minor.
You are appearing 1, 2, 3, 4, and 5?
And 5. Yes, my lord.
Mr. Arvind Lal appears on behalf of respondent number 1 to 5. Full stop.
Yes, my lord.
Who is 6?
6 is the owner of the vehicle. Isto Murmu.
Yes, take notice, service of notice. Who is appearing?
Lordship?
Fresh notice to respondent number 6.
Obliged, Lordship.
Requisites 3 weeks.
Obliged, Lordship.
Serial number 14 with serial number 15, 16, 17, 18, 19, and 20. Serial number 14, MA number 594 of 15, Mr. Baso Chatterjee for the appellant, Mr. Nikhil Ranjan for the respondent.
My lord.
Yes, Mr. Chatterjee, what is this?
My lord,
All the
We have
delay.
filed this application. We have filed this appeal. And as per the orders of this honorable court, my lord, we have deposited something also.
Mr. Chatterjee, delay has been condoned or not in these cases?
Don't.
594. 594 delay has not been condoned. Yes, Mr. Nikhil Ranjan?
Yes, Your Lordship.
You wanted to file wakalatnama in 594?
Yes, Lordship, I filed my wakalatnama.
You filed your wakalatnama?
My name is appearing, my lord.
How many days delay?
72 days, my lord.
So I'm condoning this delay.
Delay is 72 days.
Obliged, my lord.
The other connected matters, defect, the delay has already been condoned. Vicky, I heard the counsel for the parties. There is a delay of
72 days, my lord.
Where is the IA? Where is your IA? You have not filed any IA. You're conducting the delay, Mr. Chatterjee.
My lord, it is 72 days, my lord.
Where is your application under Section 5 of the Limitation Act?
I have got the I have
Uh,
filed it, my lord.
just a minute, let me see what is this petition. Yes, IA number so trade for condoning the delay of 72 days.
72 days.
You are writing 23 days. The office has pointed out 67 days. Then make the corrections. The delay in 67 days in filing this appeal. The reasons for delay has been mentioned in paragraph 2 and 2, 3, 4, 5, 6, 7, 8, 9 of the application. Full stop. Being satisfied with the reasons shown, I'm inclined to condone the delay. Delay condoned. List all these cases under the heading for admission.
My lord, may I pray one thing, my lord? The first case, my lord, I could not attend.
No, I don't know what order has been passed. You contact my office.
All right. Okay. Nothing matters.
Serial number 21, MA number under the ID for admission, serial number 21 with serial number 22, MA number 150 of 50, Mr. Prateek Kumar for the appellant, Mr. Arvind Kumar Lal for the respondent in serial number 22, Mr. Arvind Kumar Lal for the appellant, Mr. Prashant Kumar Srivastava, Mr. Prateek Kumar for the respondent.
My lord, the second case, item 22, is for enhancement, my lord.
The first case is by the insurance company, MA 150 of 2015.
150 or 150 is the first case.
First case,
Yes.
and 186 is for enhancement.
Yes, let us see.
Lords, in the first case, the ground of appeal by the insurance company are twofold. One is on the basis of driving license, and the other is on the ground of quantum as well. As regards the first ground, Lords, is concerned, the ground which was taken was that the driver was not duly licensed. The owner did not appear, Milords, debarred from filing WS, and Milords, the driving license was also not produced. Now, the learned tribunal, Milords, has said that since the investigation report has not been produced, as such, it will be presumed that the insurance company has not been able to prove its case. So, Milords, in that regard, Milords, since the insurance company had specifically pleaded that the driver was not duly licensed, and Milords, the basic facts had to be pleaded and had to be proved. Milords, once the insurance company sets up that plea, then in view of 2018 Volume 3 SEC 208, Milords, Pappu versus Vinod Kumar Lamba, para 13, where Honorable Supreme Court has also reiterated that view. The basic facts have to be pleaded and proved by the owner. It cannot shirk its responsibility because there is a proceeding before a court and the breach of violation of policy is involved. So, Lords, and regards the second point, Lords, is concerned, as regards the quantum is concerned, Lords, the pleading in the claim application was that the deceased was working in a paper conversion, Kailash paper conversion company. The salary certificate which was produced was in respect of one Chaudhary construction, and that has been accepted. Exhibit 2. Lords, I'll just place the certain point. And Lords, another aspect is, under the conventional heads, 2.25 has been granted. 1 lakh for consortium, 1 lakh for loss of love and affection, and 25,000 for funeral expenses. That is also, Milords, would be illegal in view of the Pranay Sethi is concerned. And Milords, the other aspect is, Milords, that the salary certificate, if your lordship sees, it is a post-litem evidence. The date of accident is of June 2009, and that exhibit 2 salary, which is beyond the pleadings, contrary to the pleadings, is of the year 2010. That has been accepted on the basis of one so-called employee who stepped into the witness box, and he sought to prove that a piece of paper as a salary certificate. Lords, firstly, it was beyond pleading, could not have been allowed. Even if it's a summary procedure just to ends of justice, then at least there had been some explanation given by the claimant, or some amendment, or some explanation that how this thing that Kailash paper conversion is mentioned in the claim application, and they're bringing on record something different of a Chaudhary construction. That was never explained by the claimant. Lords, as regards the fact that evidence beyond pleading is inadmissible. Now, just to give some leeway to the claimant, even in a summary inquiry, Lords, that primarily cannot be accepted until unless it brings to the notice of the court under circumstances why it happened, and what circumstances. Now, may I just place certain paragraphs of the claim application, Lords, which is Annexure 1.
Yes.
Lords, may kindly see page 34, running page 34, which is part of Annexure 1. It says rupees 15,000 per month approximately from all sources. From all sources. And thereafter,
Yes.
Lordships, may kindly see page 37. The source of income has been given. It is so vague that, but nowhere it says about Chaudhary construction. Subpara 5. That it is stated that the deceased was having a high experience of job. He was experienced person for computer works. He was having 2 years experience of motor vehicle business with Basudev Company, and 2 years experience at Moon Paper and Machinery Private Limited, Assembly Department, Udyog Nagar, Delhi, so and so, as well as 3 years experience as program associates in HIV/AIDS control under NGO. He was earlier also a marketing executive of all kinds of parts of work, courier, mobile, phones, etc. as field worker. At the relevant time of accident, he was employed in the establishment of Kailash Paper Conversion Private Limited at Ranchi. So the specific case was that he was working there. As regards the other documents are concerned, no specific evidence has been led as regards what was the income with regard to those sources of income, those places of income. Lords, as regards the written statement is concerned, para 6, Lords, it has been stated that if on verification of the driving license from the concerned DTO office, it is found the driver of the vehicle was not having a valid and effective driving license to drive the insured vehicle on the date of alleged accident case, the owner of the insured should be solely made responsible. So, Lords, at least a specific defense was taken that we are not actually saying that the driver was duly licensed, but the driver did not file WS. He was debarred, and thereafter he did not even produce a WS, Lords. Now, Lords, as regards the 2 documents which have been filed, Lords, one is Exhibit 1 and Exhibit 2. Exhibit 1, Lords, I'll just come later on. Lords, may kindly see Exhibit 2 for a moment, for which I had advanced arguments. Lords, Exhibit 2 is page 47. This is Messrs. Chaudhary Construction, dated 16/6/2010. Date of accident is 23/6/2009. Now, this document, to whom it may concern, if your lordship sees the signature, it's just a scribbling, and the person who comes to swear he has not disclosed who has signed it, whether he knows that person. He just says that I am an employee of Chaudhary Construction. Now, this document even does not specify how, where, what kind of.
Who is the owner? Who is the owner of the vehicle?
Lords, I am for the owner of the vehicle, my lords.
Yes.
My lords, in this case, admittedly, note.
Have you challenged this order for your additional evidence which has been
Against my lords.
Yes.
Since there is no finding against me, my lord, there is no finding, my lord, there is no finding against me. Now, the best case of the appellant before the MSCT was that if on verification this is found to be fake or false, so they have not submitted any verification report to the effect that the license is not genuine. There is nothing to that effect. They are not denying specifically that the driver was not holding a valid and effective driving license. They have not denied this on specific terms, my lord. I mean, permitted to place the written statement again, which my friend has also placed.
No, you have not filed the written statement. You are.
My lord, the written statement of the owner, written statement of the insurance company.
You did not appear.
My lord, I did not appear, my lords. I appeared, my lord, but for reasons best known, the written statement was not filed by us because no specific leave was taken by the insurance company to the effect that I have violated any terms and conditions of the policy. I mean, permitted to read. एक बार लॉर्डशिप हम वो फिर से पैसिव स्पर्ट देते हैं.
Just a minute. Was the driving license before the court?
My lord, it does not appear so, my lord. We filed an application over here, my lord, which had been dismissed because I was not able to explain under Order 41 Rule 27. I was not able to explain why I did not produce this document earlier. But still, under Order 47 Rule 27, the lordship got ample power to call for and see the document, my lords. I have annexed the verification report of the concerned DTO that the driving license was genuine. Now, my lord, I pose a question to myself. No plea has been taken specially by the insurance company to the effect that the DL is fake.
Yes, Mr.
So that.
Lords, as regards my learned friend's submission that he can lead evidence under Order 47 Rule 27, Order 41 Rule 27 is concerned, a person who does not file pleadings, the written statement, Lords, can only cross-examine a witness, cannot lead evidence. This is a settled proposition of law. He cannot introduce documentary evidence. He cannot because if your lordship sees Order 41 Rule 27, it starts with non-obstant clause. Even if he has filed WS, suo moto, or just by that pro tanto, he cannot be allowed to lead evidence. Only on special circumstances, the notwithstanding clause will certainly apply in respect of a person who has not even filed WS. He cannot be permitted. He is absolutely debarred from leading any evidence. Now, Lords, as regards the contention of my learned friend as regards specific reading is concerned, Lords, we have only submitted that may I just read two paragraphs, Lords? One paragraph I've already placed. Another paragraph is para 4 also. That the insurance policy is a contract between the insured and the insurance company, and like other contracts, there are certain terms and conditions of the insurance policy. One of the essential conditions of the policy is that the driver of the insured vehicle must holding a valid and effective driving license on the date of alleged accident, else on account of violation of the policy contract, this opposite party will not be liable to indemnify the insured in this case. So, my lords, and he did not file WS, he did not even bring on record any document. The claimant also could have produced this driving license, my lords. Now, my lords, once he has been debarred.
What is the driving license?
Now, my lords, may kindly see the finding part of the learned tribunal, my lords, on this aspect.
Yes.
Firstly, Lords, my submission, Lords, which has been mentioned, Lords, may kindly see in the award, Lords, at internal page 5,
Yes.
para 13.
Yes.
Advocate appearing on behalf of the insurance company submits that the driver of the offending truck, the DL, has not been brought on record, nor there is any evidence that any of the vehicle particulars of road permits, etc., has been brought on record, and therefore the insurance company is not liable to indemnify the owner, and hence the liability, if any, is that of the OP number 1. Now, Lordship, kindly see the finding part, para 17. Next
Yes.
page, internal page 6. Certain question of is raised, of course, is in course of argument relating to the validity of DL and other documents of the offending vehicle. Apparently, the owner was not has not contested, but simultaneously the insurance company has not produced the investigation report, allegedly prepared by the investigator, to show that there was no defect in the documents of the driver of the offending vehicle or the offending vehicle itself. Under such circumstances, the adverse inference shall be drawn as the insurance company have withheld the document in its possession, and tribunal concludes that there was no defect in vehicular documents, nor there was any defect in the DL of the vehicle. So the adverse inference could have been drawn if there was a direction to produce a document.
Mr. Ashutosh, why not adverse inference be drawn against you for not producing any other documents? Yes? Why not adverse inference be drawn against you, Mr. Ashutosh Anand?
My lord, if I am permitted to replace para 6, it starts if on verification. So if on verification means
yes, what is
एक बार बस if on verification मतलब होगा कि they had in possession the driving license, it was to be verified. अगर वेरिफिकेशन का हम बात कर रहे हैं, अगर मेरे पास ड्राइविंग लाइसेंस होता तो हम बोलते हैं I don't have a driving license, the driving license is fake. They say they start with the statement if on verification. So the normal corollary means I have a document with me, and if it is on verification, if it is found to be fake. Second, my lord, even if we go by this one single judgment, my lords, your lordship is well aware that in that case, the entire liability upon the insurance company to avoid its liability by leading cogent evidences. There has to be specific pleading to that effect. In this case, there is no pleading by the insurance company that the deal was fake. And your lordship, even under, I am not sitting under Order 41, Rule 27, 1, my lords. I am bringing under Order 47, Rule 27, 1B, my lords. It says the appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment or for any other substantial cause. So additional evidence may be called by this appellate court even, my lords. Because an issue which was not raised by the appellant before the MSCT court during the course of pleadings, first time raised during course of argument, and that has been denied. Thereafter, first time raised in the memo of appeal is being contested. A pleading has to be specific, my lords. If I am being debarred, so is the insurance company is also required to suffer for their own fault. There was no pleading. Till date, they have not produced the verification investigation report before this honorable court.
Okay. And what about Mr. Arvind Lal?
Yes, my lord. In this case, my lord, regarding income, so much argument has been made by my learned friend, income. My case was that he was earning 15,000 rupees per month, and my learned friend has gone through the statement in my claim application, that is in para 37, that he has not read, that it is stated that the deceased was having a regular income of 15,000 to 18,000 per month, approximately from all sources, from his salary and part-time job, as well as from agriculture. Now, kindly see, my lord, part-time job, it has been mentioned that Chaudhary Construction is given part-time job. Certificate is of part-time. Although Kailash Paper Construction, they have not given any certificate, therefore it was not produced. But even in FIR, it has been mentioned that the deceased was working in Kailash Paper Construction. Second thing, my lord, what was the qualification? My learned friend of the from insurance company, they have annexed one document, my lord, that is in page 46. Kindly see, my lord, annexure 3. In that case, one offer of 70,000 rupees per month was given to the deceased, the letter dated 8/6/2009 and date of accident just after 1 week, 15 days, that is 23/6/2009. He was capable to earn that amount, my lord. He was offered on 8/6 that 70,000 rupees in outside India he will be given. Within 10 days, 12 days, he died, my lord, in a road accident. Therefore, for a person who is having passport,
who proved that letter?
That is exhibit 1, my lord, not challenged by the insurance company.
I'm asking you, who proved that letter?
Yes. On without objection, it has been marked exhibit, my lord.
That piece of paper has
But the LCR would be needed. Because the learned friend is submitting something which is not there on the award.
That is in
We have
insurance
very
company's
fairly produced this document, but your lordship may kindly consider one thing. This document, why we have produced it, if your lordship sees, this says that Sunshine Enterprises. Now it claims to be a placement agency. Now placement agency, it says that in favor of Anand Kumar. Now it says on the basis of your working so-and-so provisional interview, you have been provisionally selected. But there is no signature. No, but there is no signature of a person who, I mean, at least the signature is there, but the person ought to have come here because this document cannot be, treated to be in evidence, because formal proof, even in a summary proceeding, which actually has a vital bearing on the, because even otherwise, Lords, the law is well settled. Even if there is an offer, that offer cannot be treated to be a document of income.
No, therefore I'm not claiming that he was earning 70,000. He was offered, and therefore before going there, he was earning 15,000 rupees.
You have not proved this document.
Yeah.
The fundamental thing is
my lord, because this is a tribunal proceeding, and strict proof of a document is not required at all. After waiving the formal proof,
Mr.
and if the insurance company might have challenged that document, then they have to bulai lete unko.
In these type of cases where income certificate can be easily procured or manufactured, it is necessary it needs
that
to
may be that can be, my lord. But what he was capable to earn, but 70,000 rupees was offered, and I am claiming 15,000 rupees. Court had considered 8,000 rupees.
And there is one thing, Lords, I just wanted to say something more, Lords. 50% for future prospects has been granted, and 9% interest has also been granted, Lords, from the date of admission. So those two aspects may also kindly be considered ultimately.
From a quantum is concerned, my lord.
Both these appeals will be heard. Admit, call for original law court records.
In this case, my lord, insurance company has not paid a single pie, my lord. So some amount may kindly be directed to pay, because.
Excuse me, what? I'm not staying.
Let the lower court record be called for.
Yes. Call for the original lower court record.
Serial number 23, MA number 224 of 15.
Okay.
Mr. Arvind Kumar Lal, Mr. Chetan Kenale, for the appellant, Mr. Sunil Kumar, Mr. Rohit Ranjan Sinha, Mr. Chitanand Sahai, Mr. Kamdev Pandey, Mr. Vishal Kumar for the respondents.
My lord, I am for the claimant for enhancement. I have come, my lord. So far, this case is concerned, my lord, my vehicle was not insured.
Vehicle was not insured.
Not insured.
Who is the owner?
My lord, I am for the respondent number 2, owner of truck number 2205, my lord.
Award is against whom?
My lord, award is against me and the another truck owner, between which head-on collision was there, my lord. And,
who appears on behalf of the other truck owner?
Notices were issued, my lord, on the last occasion.
This case has been admitted.
From the order sheet uploaded, it doesn't appear so much.
Yes, my lord. This case has already been admitted earlier, as per my.
This case has already been admitted on 2/8/2019. but wrongly in order dated 3/1/2022, it has been directed to list this case under the heading for admission. So thus, the order dated part of the order dated 3/1/22 is recalled. This is under the heading for hearing.
Serial number 24, MN number 255 of 15, Mr. Manish Kumar. For the appellant, Mr. Manish Kumar, Mr. Shamati Reddy, Mr. Arvind Puryavati, Mr. Jayadaman, Mr. Nandit Kumar, Mr. Dipesh Kumar Nirala for the respondent.
Lordship, this case may kindly be passed over. Mr. Manish Kumar has requested me. He is engaged in some other courts, Your Lordship.
This is appeal by the insurance company.
Your Lordship.
What are the grounds?
On the ground of fake permit, Your Lordship.
Who are you?
I am on behalf of claimant, Your Lordship.
Who is for the owner?
They have also appeared.
Your Lordship, I am appearing on behalf of vehicle owner. Today itself, I have received instruction to appear on behalf of respondent number 5, Your Lordship, who is the vehicle owner. I was seeking adjournment as a matter of last indulgence, Your Lordship, since I have not got the brief.
Mr. Navneet Kumar. Navneet Kumar, what is your name?
Navneet Topo, Your Lordship.
Mr.
Navneet Topo.
Mr. Navneet Topo submits that today itself he has received instruction to appear on behalf of respondent number 5.
Your Lordship,
Respondent number
5, Your Lordship.
5.
Jan Kumar Kedia. 5.
So he is alive? Respondent number 5 is alive?
Your Lordship.
Yes?
He is the owner.
He is the owner. We have respondent number 5. First up. You have not filed wakalatnama.
Your Lordship, I had already filed wakalatnama. Some other lawyer was conducting the case. Now, Your Lordship, I have received instruction that I should conduct the case on behalf of respondent number 5.
So you have appeared in 2018 on behalf of respondent number 5.
Your Lordship, but my brief is not with me, therefore I was seeking.
Your wakalatnama is there.
Yes, Your Lordship, I had already filed wakalatnama. One of the advocate, Dipesh Kumar Nirala, was appearing on behalf of respondent number 5, but his license has been revoked, Your Lordship. Therefore, I would be appearing on behalf of respondent number 5.
Whose license revoked?
I mean, he has suspended his license because he has joined some other services, Your Lordship. He is working somewhere else.
Okay. First of all, give Mr. Navneet Topo prays for 1 week's time.
Obliged, Your Lordship. Only 1 week.
This is this case after 1 week.
Serial number 25, MN number 258 of 15, Mr. Vijay Kumar Sharma for the appellant, Mr. Rahul Sadhu, Mr. Arav Sinha for the respondent.
Lordship, serial number 25, counsel for the appellant, Mr. Vijay Kumar Sharma, has gone to outstation, Lordship. So I am pray for 1 week time, Lordship.
This for enhancements.
Yes, Your Lordship, enhancement, Lordship.
Prayer has been made to adjourn this case on the ground of absence of Mr. Vijay Kumar Sharma, learned advocate, appearing on behalf of the appellants. Prayer allowed is this case after 1 week.
Obliged, Your Lordship.
My appearance may be noted, my lord.
Give your slip.
Respondent number 1.
Give your slip.
Much obliged.
Serial number 26, MA number 463 of 15, Mr. DC Jha for the appellant, Mr. BN Oja, Mr. Naveen Kumar Ganji for the respondent.
Yes, Lordship. This appeal has been filed by the insurance company on the ground of driving license, Your Lordship. And the driving license of the driver who was driving the commander jeep. I am audible, Your Lordship?
Yes, yes.
Yes. Yes, Lordship. The two issues has been framed. Issue numbers 6 and 7, Your Lordship. That is in para 10 and 11.
Yes.
That we can be seen. But outside I am saying, Your Lordship, that the issue number 6 and 7, para 10. The specific case of the OP number 2, the New India Assurance Company, is that the driver of the offending vehicle was driving the vehicle without valid and effective driving license, and PSP badge was not allotted to him at the time of accident. The owner of the offending vehicle was required to prove all the documents related to the offending vehicle, but it miserably failed to produce the same. It further contended that the surveyor has verified the driving license of the driver from the office of the issuing authority, that is DTO Ranchi, and it was reported that on the date of accident, the driver offending vehicle was not authorized to drive passenger service vehicle, and thus there has been a breach of condition of policy on the part of the owner of the vehicle. Therefore, according to OP number 2, since there was a breach of terms and condition of the
this issue has been decided.
Yes, that I was about to say, Your Lordship, that the outset I said, after coming of the judgment of Mukund Devgam, Your Lordship. And that is, Lordship, AIR 2017, Supreme Court 3668.
What is the name of the party?
Party's name is Lordship Mukund Devgam versus Oriental Insurance Company Limited.
What is the SCC citation, parallel citation of the SCC?
SCC citation is not with me, Your Lordship, because I am having.
So your first ground is that he was not authorized to drive passenger service vehicle.
Yes, Lordship. And on that basis, Your Lordship, the tribunal has given.
Yes.
It has, in next paragraph, it was held in para 11, Your Lordship, after having heard the learned counsel OP number 2 insurance company of going through the record, it appears that Exhibit A surveyor's and valuer's report enclosed there is with Xerox copy of the certificate of driving license, particulars granted DTO Ranchi, that the driver of the offending vehicle not authorized to drive passenger vehicle on the date of accident. However, he was authorized to drive passenger service vehicle with effect from 10/3/2005 after accident, that is after the accident. And on that basis, Your Lordship, it was held that the insurance company could not escape from its liability, and the insurance company will pay and recover it from the owner. That liberty has been given, Your Lordship, in para 14, Your Lordship. Last 4 lines. Para 14, page 8 of the judgment.
Yes.
As held above, the offending vehicle was being driven by the driver who was not authorized to drive passenger service vehicle. Therefore, in terms of section 149(2) MV, the defense
was authorized to drive what? Which category of vehicle?
He was having license for LMV, Your Lordship. He was driving the commercial vehicle. That's why I said that this point has been decided in.
What was the vehicle which was involved in the accident?
Commander Jeep, Your Lordship.
So that is a light motor vehicle.
Yes, Lordship. Yes, Lordship.
It is admitted. The Jeep
Yes,
is a light motor vehicle.
So on that basis, Your Lordship, right to recovery was given to me.
So you cannot get right to recovery in view of the judgments of the Honorable Supreme Court.
And in this case, Your Lordship, on 6/2/2018, while we are pursuing the stay application, we were directed to deposit 2 lakhs rupees, Your Lordship.
Now what is your other ground?
That was my sole ground, perhaps, Your Lordship. That was my sole ground.
You don't raise any other grounds?
No. Though we have taken the ground of permit, but it has been answered in the same paragraph because for permit point, nothing has been brought on record, Your Lordship. In same paragraph, Your Lordship, it has been dealt.
So, what is the parallel judgment? 2017 AIR, like 2017 AIR Supreme Court 668. Mukund Devgam.
Mukund Devgam.
Can anyone give me the parallel citation?
Mukund Devgam, Your Lordship.
So this is not a violation as per the Supreme Court judgment.
Present situation is that, Your Lordship.
So if this is not a violation, you have no right to recover.
Yes, this is the present.
You have no right to recover.
Yes, Lordship.
Pay the amounts. Take down. Heard the learned counsel for the appellants. Insurance company. Anyone appearing on behalf of the respondents?
I am appear on behalf of respondent claimant, my lord.
And Mr. Naveen Kumar Ganju is appearing on behalf of the respondent claimant. Next slide. This appeal has been preferred by the insurance company, by the New India Assurance Company Limited, challenging the award dated 20th of June 2015 in compensation case number 110 of 2005, passed by presiding officer MACT Ranchi. Same line. Next line. By the aforesaid award, the tribunal has awarded a compensation to the tune of 3,01,000.
3,51,000 less 50,000.
3,51,000.
Less 50,000.
To the claimants. And
she was a housewife, 45 years of age.
On account of death of a housewife, aged about 45 years.
On 22/10/2004.
The counsel appearing on behalf of the appellant submit that the tribunal committed error in directing the insurance company to pay the amount of compensation. Full stop. He submits that the tribunal, after weighing the evidence and after going through the documents, have held that the driver of the offending vehicle was not authorized to drive a passenger service vehicle, on the date of accident. He submits that when the driver was not authorized to drive the aforesaid vehicle, there is a violation of condition of policy, and that being so, the amount of compensation should have been directed to be paid by the owner of the vehicle, absolving the insurance company of their liability. Full stop. This is the only ground taken by the appellant insurance company. It's a taken and argued. Full stop. Next para. Since the ground of appeal is limited, I am not entering into the factum of the accident, the quantum, and other aspects. Full stop. I am limiting my this order will be limited only in respect of the point raised by the insurance company. Full stop. Next para. Vehicle number JH01C 4549 met with an accident as the vehicle was being driven in a rash and negligent manner. The deceased was a passenger of the same vehicle. Full stop. The vehicle was a Commander Jeep and was admittedly insured with the appellant. Full stop. From the records, I find that the vehicle was being driven by a driver who was having a valid license. Full stop. The only point which has been raised is that though the driver was having a valid license, but there was no endorsement to the effect that he could drive a passenger, uh, he could drive a
Passenger service vehicle.
service vehicle. It is the case of the insurance company that the license was issued to the driver, permitting him to drive a light motor vehicle, and there was a full stop. As per the insurance company, the Jeep, which is the offending vehicle, is also a light motor vehicle. Full stop. The tribunal has held that there was no endorsement in the license allowing the driver to drive the vehicle, to drive a passenger service vehicle, and in absence of said endorsement, the tribunal held, in absence of said endorsement, the tribunal held that there was a violation of the policy, as the driver was not authorized to drive the passenger service vehicle. Yes, Mr. GCJ, what is the reference we are given?
Reference is AIR 2017,
Yes.
Supreme Court 3668.
3668.
3668.
Lord,
3668.
SCC citation is there if your lordship permits. I may say.
Yes. Give the SCC submission. Citation.
Yeah, lordship. 2017, volume 14, SCC, page number 6.
Just check 2017 is here or not. 2017 SCC.
Volume 14, page 663, my lord.
Volume 14, 663.
My lord.
Just check whether 2017 is here. Thus, the issue which the insurance company is trying to rec up is that even if a person is holding a driving license, permitting him to drive a light motor vehicle, but for driving a passenger vehicle, he needs a special permission, oblique endorsement. And in absence of such endorsements, it will be treated that there's a violation of terms and conditions of the policy. Full stop. Next paragraph. The aforesaid issue has been set at rest by the Honorable Supreme Court in the case of so-and-so versus so-and-so, reported in 2017.
Para 46, sub para 1, Your Lordship.
Yes, para?
46, sub para 1.
In 2017, SCC, volume 14, 663.
Only four lines. If you permit, I will read, Your Lordship.
Yes, read it.
Light motor, para 46, sub para 1. Light motor vehicle as defined in section 2 of 21 of the Act would include a transport vehicle as per the weight prescribed in section 2 by 21, read with section 2 of 15 and 2 of 48. Such transport vehicle are not excluded from the definition of light motor vehicle. This ratio has been decided.
The Honorable Supreme Court, in the aforesaid judgment, has held that a light motor vehicle includes a light motor vehicle used as a passenger service vehicle. Full stop. It is necessary to quote the relevant paragraphs of the aforesaid judgment. Full stop. Colon dash. Mr. Counsels, if you were to refer to any judgment, just send a WhatsApp message in advance to the court master so that they can prepare with the books, keep the books here. There is no appeal by the owner?
I don't have any idea. Perhaps not. Because right to recovery in operative part has not been given. In findings, it has been given, Your Lordship, but in operative part it was not given.
Who said? In paragraph 14?
Yes, Lordship. In paragraph 14?
Yes.
Last four lines, Your Lordship.
The insurer is at liberty to recover the amount from the insured.
Yes, Lordship.
That is the owner. So now, but that is also gone now.
And in operative part, it has not been.
There's an old saying that there's a very old Hindi saying, Mr. G.C. Shah.
Yes, Lordship.
There's a very old Hindi saying, बनने चले थे कुछ बन के आ गए कुछ.
Lordship, the correct position है. We are
in this case, my lord, owner must, my lord, not appeared, my lord. Vehicle owner not appeared.
क्या लिखे? Full stop.
Lordship, when the judgment was passed in 2015, at that time this judgment was not.
Refer to AIR. Don't give the AIR reference. Don't give the SEC reference. Give AIR 2017. Supreme Court 3668. So and so versus so and so. Full stop. Its quote as follows: 46 dash small Roman 1. Quote. Thus, from the aforesaid judgment of the Honorable Supreme Court of India, it is clear that a light motor vehicle will include a transport vehicle, will include a light, a transport vehicle of the same class. First up. Admittedly, in this case, the driver was holding a driving license to drive a light motor vehicle. Thus, in terms of the aforesaid judgment, he was authorized to drive the passenger service vehicle, which is a transport vehicle. First up. As held earlier, admittedly, the vehicle which the driver was driving was a light motor vehicle. First up. Considering the judgment of the Honorable Supreme Court, I find that considering the judgment of the Supreme Court, the finding in respect of issue number 6 and 7 of the impugned judgment, whereby it has been held that there was a violation of the policy since the driver was not having an endorsement. Since the licensing authority did not endorse the driver to drive a passenger service vehicle, is erroneous and cannot be sustained. Thus, the aforesaid finding is set aside. Full stop. Since there was no violation of policy, the right to recover, the judgment by which right to recovery has been granted, the part of the judgment by which right to recovery has been granted is also not proper. Full stop. Thus, the ground which has been raised by the appellant insurance company has got no legs to stand in view of the judgment passed by the Honorable Supreme Court. Full stop. This appeal is thus dismissed.
The statutory amount.
The statutory amount which has been deposited by the insurance company is directed to be refunded to them.
Serial 27, MA number 480 of 15, Mr. Pratish Kumar for the appellant, Mr. Pratik Sen, Mr. Amit Chandra Mishra, Mr. Rita Kumar for the appellant.
Look, this is an appeal preferred by the insurance company, my lords. Lords, the only ground of challenge would be the quantum, my lords. And my lords, the ground of appeal would be, my lords, that there is a head-on collision and the deceased was a pillion rider in a motorcycle, and there was a head-on collision with another vehicle, my lords, that is the insured vehicle. And as such, my lords, since the deceased was was riding in the vehicle as a triple rider, my lords, in the motorcycle, and as such there was a head-on collision with a trucker, the insured trucker. So, my lords, since the Motor Vehicle Act provides, my lords, that in a pillion, that is a motorcycle, there cannot be more than one passenger apart from the driver. And since there was overloading, and the deceased Uday Kumar Singh was a triple rider in that vehicle, and as such, my lords, there's a contributory negligence on the part of the deceased also, my lords. Now, my lords, before I take lordships to this aspect, my lords, there is one judgment of the Honorable Supreme Court on 2020, in which the Honorable Supreme Court has said, in 2020, Volume 3, SEC, page 57. Lords, in that case, the Honorable Supreme Court has said that if the person is
Page
57.
Yes.
Lords, I need to distinguish this decision, Lords. That is, my lord, subject to my lord's kind consideration. Lords, there were two distinguishing facts, Lords. The first distinguishing fact was that in that case, the vehicle, the four-wheeler.
No, just let me understand one of the facts. The vehicle involved is a TVS motorcycle and a tractor.
Yes.
You are the insurer of the tractor.
Trucker.
And who is the insurer of the motorcycle?
Lords, they have not implemented that, but in view of the composite negligence, because the deceased was not driving the vehicle, he was
a pillion rider.
He was a pillion rider, and it is not since I'm the insurer of the trucker, so in view of composite negligence, the law is well settled in P.O. Anthony versus K. Karnavaran, and there are similar judgments.
One of the offending vehicle can be proceeded against.
Yes, Lord, that is settled. So, but the question is, Lords, may kindly consider the judgment of the Honorable Supreme Court in 2020 on what facts that finding has been granted, Lords.
Yes.
I just
2020 Volume 3, SCC 557.
Lords, in that case, this is Lords Mohammed Siddiqui versus National Insurance. Now, in this case, there are two distinguishing facts, Lords, apart from my case. Firstly, in my case, there is a head-on collision. In that case, the four-wheeler had dashed the triple loaded motorcycle from behind. And secondly, Lords, what weighed with the Honorable Supreme Court was also this aspect, that at 2 a.m. at night, that accident occurred. In the claim application, there is an averment that at 9:30 onwards, the accident occurred. 9:30 a.m. in my case. So these two distinguishing, because of a small particular change in one small fact can make a world of difference, Lords. There's a
what is
may just place that judgment, Lords, 2020, Lords.
First, let us understand the fact of this case, then we will.
Lords, as far as the facts are concerned,
yes. What is the evidence?
Lords, as far as the evidence is concerned,
LCR. We need to go through the LCR, the evidence of the.
Yes.
Who is appearing?
Ma'am, my lords, I am appearing for the claimant.
Who is for the owner or the?
Owner has not, on last occasion, my lord had passed a detailed order that the owner has been.
Lords, we can issue notice, Lords, since the LCR has been called for, Lords, I can issue notice to the owner.
Let's see.
Even though, my lords, my memo of appeal is not directed against the owner. My lords,
You are only challenging the quantum. It's not
yes,
necessary.
lord.
Quantum on which ground?
On the ground of contributory negligence on the part of the deceased, because you are a triple rider, my lords, and then I'm going to distinguish.
The deceased was only a pillion rider.
Pillion rider.
Yes, he was a third pillion rider, my lords.
He was not the rider of the driver of the motorcycle. So however you see.
Lords, the Honorable Supreme Court has said.
So what is the negligence of this pillion rider?
The pillion rider, knowing fully well and conscious of the fact that there cannot be ignorance of law, Lord.
That you mean to say?
There is a Lord, yes,
listen to me. Then you mean to say that if a passenger travels on a roof of a bus, then he is not entitled to get the entire compensation. Similarly, the amount of compensation will be deducted after fastening liability upon him, the passenger also. This is your
as far as that full bench judgment was concerned, Lord, Girja Prasad cases. Lord,
show me in any case where the rooftop passenger Supreme Court says there will be liabilities to be apportioned with the amongst the claimant also. There will be a contributory negligence of the claimant also because he was traveling on the roof. Show me a judgment.
Can it be tomorrow?
From your argument, this analogy can be drawn that if a passenger who is a triple rider in a triple riding motorcycle, he was a passenger, so there was negligence on his part. So there is a contributory negligence.
Yes.
On part of the passenger. Now show me any judgment of the Supreme Court which fastens contributory negligence.
Honorable Supreme Court का तनी Jharkhand High Court का है, Lords. In a rooftop case, there have been deductions.
Don't show Karnataka another High Court.
No, Lords. Girja Prasad case is concerned. That was on the ground of
there are
statutory
several judgments which is before the Honorable Supreme Court, which has been passed by the Honorable Supreme Court in the case of rooftop. Or show me any of a judgment where Honorable Supreme Court fastens contributory negligence on a person who is not a driver of any of the vehicle which met with an accident. Show me.
Lords, can it be day after tomorrow, Lords? Or if your Lordship wants to decide this case today, Lords, then second half, Lords.
No, I didn't say
My Lords.
Yes.
Call for the lower court reports.
Okay.
Yes.
No. On the last occasion, my Lords had Derek relying on para 13 of this Mohammed Siddiqui's judgment, it was clearly that.
You just then think of a situation.
Yes.
Suppose a passenger carrying G. The owner comes and says the driver lost control because the passenger who was sitting as a passenger, he started shouting and started dancing. So he should be made negligent also. He has contributed towards the accident. Is it the law? Ridiculous. Lower court records. Just to see that what is the evidence of the eyewitnesses. If you contributed negligence, it will be on the owner of the motorcycle or the driver. Owner of the motorcycle. As because it was being driven by a person. Admittedly, he was not the driver. Yes.
Lords, if Lords may be permitted to issue notice to the respondent owner.
Is it your
respondent owner पे notice कर देते हैं because.
You have not taken that ground also. Have you taken that ground?
No, Lords, we have taken only ground of contributory negligence. Since he is arrayed as a party.
Contributory negligence of the deceased.
Deceased only.
It's concept. I'm not in agreement. Yes, next.
In these two cases, my lords, on 15/12/2001, direction was to put up the cases in physical court, my lords, because I have to go through the Marshal CR. I am also challenging the quantum. One of the ground is that, my lords, on the basis of only, my lords, estimates amount towards medical expenses has been given to the claimant.
Which two cases? There's an order, judicial order?
Yes, my lord, on 15 December 2021.
In view of the order dated 15/12/2021, this case has been wrongly listed in this virtual hearing.
My lord.
Serial number 30, MA number 251 of 17, Mr. Agarwal for the appellant, Mr. Ritesh Kumar, Mr. Saibal Kumar Lal, Mr. Sumit Toleria, Mr. Akshay Kumar Mango, for the respondent.
In this case, at the outset, I would like to submit before Your Lordship, my lord. On the last occasion, I was directed to deposit to remit the amount to the bank of the account of the claimant. My learned friend, Mr. Elskil Layak, has sent the photo of the passbook, etc., on my WhatsApp. And I told him, give me the photocopies of the passbook. And I'm not able to download the photos which have my learned friend has sent. So I requested him to send, but he said he has not given me the photocopies of the bank passbook and other details, Aadhaar card.
Aadhaar card is not necessary. They will not give you Aadhaar.
Yes, he can give the photocopy of the bank passbook only.
The photo of the bank passbook has been sent in WhatsApp to you.
I'm not able to download it. Still, I'm not able to download it.
Forward it in WhatsApp to your client.
But I'm not able to download it, Your Lordship. I'm not able to download it. It will not be forwarded. Unless
that is not opening.
It is not opening.
Mr. Layak, send another WhatsApp. That WhatsApp is not opening. Yes, Mr. Layak.
My lord, in WhatsApp, my lord, I will send.
Yes, send another WhatsApp just now.
Very well, my lord.
And send a WhatsApp to my court master also.
Very well, my lord.
Well, that would be easier if my lord when gives you the photocopy of those documents. Well,
He wants specifically the photocopy. That is the main reason.
Why? We are heading towards. We are slowly heading towards a paperless regime.
That is true, but those things are to be kept on record of the office insurance company, because WhatsApp I'll be sending it to the office.
Yes.
To the one of the officer concerned.
My lord, let the case be decided finally, my lord. Let the case be decided.
Okay.
Yes. There are two appeals.
There are two appeals. One appeal is filed by me. In this case, my appeal, the learned tribunal has come to a finding. My appeal is only limited to that whether the Lions Public School is supposed to be sufficiently solvent, whether in those cases the right of recovery can be given or not. Because the right of recovery, principle of right of recovery is to be given in cases where the tribunal is not sure whether the insured the victim will be able to recover the amount or not. So my appeal is only to that ground. Whether in every cases a straight-jacket formula can be applied for a right of recovery or not. Because
well, let me hear the appeal of the school first.
Yes.
Lordship, I'm appearing for appeal, my lord, in the second matter.
Yes.
But in this matter, my senior has to assist your lordship, my lord. He's before division honorable division bench, my lord. I'm only appearing for passover, lordship, this matter.
Mr. Counsel, sorry, a claimant who is suffering and is not getting the benefit of the award in a death case is running from pillar to post for money. What is the amount?
3 lakhs we have deposited in terms of order dated 21/6/2017.
What is the as per award?
As per the award,
6,53,000.
6,53,000.
What is, yes, Mr. Ritesh Gupta, what is the ground for your challenge?
Lordship, in this matter, lords, the learned court below has stated, lordship, that the driver of the offending vehicle was not having a valid driving license. And however, lordship, by exhibit 1 of which we have submitted before the court below, lords, we have given the driving license of the driver, and my lord, even a separate case was registered against the driver for rash driving, and that case fire, he has been acquitted, Lordship.
Exhibit.
I'll just
Exhibit A.
Yes, Your Lordship.
Exhibit A. Read the issue. Read the issue.
Issue number 5.
Issue number 5, Lordship. Whether the driver may be Lordship.
Yes. Read that. Read that.
Issue number 5, Lord. Whether the driver had valid driving license at the relevant time. This was the issue number 5, my lord. And in this connection, my lords, we have given the driving license that was issued by the DTO Dhanbad, being driving license number 16180/92/OD, and that was marked as Exhibit A.
The discussion is at page 6 of the award. Issue number 5.
Yes, Lordship. Page 6, Lordship.
Spilling over to page 7.
Who was the driver?
Yes, Lordship. Jay Prakash Yadav was the driver.
NBA. This license was earlier issued from Kanpur.
Kanpur, yes. It was found to be fake. We have proved it.
How?
That is the evidence of my witness. That would be apparent from page 6. I am reading it. Investigate. The opposite party number 2, the New India Assurance Company Limited, has stated in paragraph 1. The opposite party number 2 got one witness examined in this case, who is DW1, namely SM Rizvi, Ahmad Rizvi. This witness, deposing on behalf of the opposite party number 2, New India Assurance Company Limited, has stated in paragraph 1 of his evidence that he was deputed as investigator by the New India Assurance Company Limited for verification of driving license number D228/KP/1984. This witness has further stated that the said driving license is said to be issued to the Jayaprakash Yadav on 9/4/84, the licensing authority Kanpur. This witness has identified and proved the photocopy of the driving license as Exhibit B. This witness has also identified and proved his report that in respect of same Exhibit B/B/1, in which he has stated that the clerk of RTO told him that the said license was not issued from his office, as the DL shows code D. The code D and code D is used only for those persons whose first name begins from alphabet D, whereas the name of driver begins from J alphabet. That is Jayaprakash Yadav. This witness has last stated in his report that Exhibit B/1 is the driving license of the Jayaprakash Yadav of the vehicle in question is fake one. Comparing Exhibit A and Exhibit B, it pertains to the same person, Jayaprakash Yadav, who is said to be driver of the vehicle in question at the relevant time. Document Exhibit A is a letter of district transport, where the document B is the photocopy of driving license issued itself, and the same Jayaprakash Yadav. Although Exhibit B has been marked with objection, but the learned counsel appearing on behalf of the opposite party number 1 could not point out any aspect of the valid objection of the time of argument into the matter. Perusing the document B, it appears that the same was issued from Kanpur Licensing Authority on 9/4/84, where the date of birth of Jayaprakash Yadav in the written thereof is 24/6/1967. This is very significant, Your Lordship. 24/6/1967, meaning thereby the said Jayaprakash Yadav was below age of 18 years at the time of issuance of the said driving certificate. The same is not possible, as the driving license is issued to a person's age of 18 years, and above there too it further appears that DW1, namely SM Ahmed Rijvi, has investigated about the said license of Jayaprakash Yadav in the office of Kanpur Licensing Authority, where the dealing clerk has demonstrated him that the driving license in question was forged one, and as such, he gave his report to the opposite party number 2. In this regard, the driving license in question of Jayaprakash Yadav is a forged one. On the other hand, nothing controverting the same has been adduced into the evidence by the opposite party number 1. The document Exhibit A is the letter of DTO Dhanbad. In respect to the driving license, Jayaprakash Yadav, if no driving license was issued by the Kanpur Licensing Authority to the said Jayaprakash Yadav, in such renewal of any driving license of Jayaprakash Yadav shall be illegal. In fact, initially issued the driving license from Kanpur Authority itself was not in existence. In therefore, in which DW1 has given his report that the same was forged one. Renewal of the driving license can take place when there is any original driving license. The DW1 report, DW1 contained in Exhibit XB/1 discards issuance of any such driving license, and of the driver of the vehicle in question, namely Jayaprakash Yadav, had the said driving license been genuinely issued from Kanpur Licensing Authority, the opposite party number 1 could have adduced the evidence, adduced the same. Nothing as such has been done. Hence, I can safely infer that Jayaprakash Yadav was no driving license to drive the vehicle in question, in which they caused the accident as with the deceased. Accordingly, issue number 5 decided.
What was the driving license number?
Driving license number was D-22KP/1984. That was the original driving license.
Who has provided this number?
It was there. It is on the driving license. Kindly see the driving license which was on record. Every driving license bears, even if the previous number. What was the earlier driving license?
Where is it? Exhibit A.
Exhibit A.
Yes.
Must be having it.
Where
Exhibit
is
A.
it? What is the number you are saying? D228KP 1984.
Yes.
Where are you getting this?
Exhibit at the back side of the driving license, which was allegedly issued by DTO Dhanbad, that number is bearing date 0904/84 Kanpur, number
You are, you
D2.
are, you are relying on Exhibit B1.
B1.
So it says that the clerk of the RTO has mentioned. Mentioned what? Already mentioned. And you mean to say I will accept this?
Which one, Your Lordship?
You read Exhibit B1?
But I don't have the copy of Exhibit B1 exhibits. I don't have the copy Exhibit B1.
Your report says that in the above reference, a driving license number so and so is given for verification. I have gone to RTO Kanpur Nagar for verification. The clerk of the RTO is mentioned that the above mentioned driving license is not issued from the office. Just on oral submission, you give this report.
The letter of DTO is also there, perhaps. Just a minute.
Where is the letter of DTO?
Just a
The letter
minute.
of Dhanbad DTO is there, which says that the license number so and so is there.
Just a minute, Your Lordship.
To answer this question.
There is one letter also, Your Lordship.
Yes.
This is to the divisional manager, New India Assurance Company Limited. लाइसेंस संख्या D22/84 के सत्यापन के संबंध में महोदय उपरोक्त विषय तक अपनी सूचना के अधिकार पत्र ध्यान
Exhibit.
Since the records are not with me,
Tell me, there are no exhibit. This is not an exhibit. That is not an exhibit.
the letter of this thing. Investigator report is also not with me at the moment, Your Lordship. Now, one thing, Your Lordship. One thing from this document I will also demonstrate that the finding of the learned tribunal, the date of birth.
You are 15 years.
Yes.
So no license could have been issued in his favor.
No license could have been issued. No license could have been issued.
What is your reply to this? What is your reply to this?
What's up? This only I was praying for short password not in this matter. That's why it's
Much time is. Where is Mr. Sumit Garodia?
he's on let's before the honorable division bench. One hearing matter is going on. That's why. Only a short password.
What password?
All right, Masha.
Serial number 32 with serial number 33, serial number 34, serial number 35, and serial number 36.
Well, in this case, I am praying for some adjournment because all these cases are arising to the same set of accident. Item number 34 and 35, I have to file the wakalatnama, my lord. Anything about 2 or 3 weeks, my lord.
You want to file wakalatnama?
Yes.
Serial number 34 and 35, we have not filed wakalatnama.
No. 34 and 35. Only the copies have been served to me. I file wakalatnama, my lordship.
Mr. Alok Lal submits that though the copies have been served upon him, Mr. Alok Lal, learned counsel, okay? Though the copies have been served upon him, he has not filed any wakalatnama. He submits that he will file wakalatnama in these two cases. He prays that this batch cases be adjourned for
2 weeks.
2 weeks. Yes, Mr. Nikhil Ranjan?
Yes, Your Lordship. Can
This
we?
is for
You informed me yesterday.
This is for enhancement.
Yeah, I have preferred appeal for 2 appeals for enhancement, and 3 appeals have been preferred by the insurance company for on the ground of on separate grounds, my lord.
Okay. On the request, the appellant, these two cases, I've got no objection. We'll submit this case after 2 weeks.
My lord.
Within 2 weeks, you file your
Yes, my lord.
wakalatnama.
That's right. That's right.
Yes.
Under the heading for hearing, serial number 37, MA number 180 of 50, Mr. Baso Chatterjee, Mr. Ashok Kumar Singh for the appellant, Mr. Ramnivas Roy, Mr. Vijay Kumar Sinha for the respondent.
Yes, Mr. Chatterjee. Mr. Basab Chatterjee. Where is Mr. Chatterjee? No one appears on behalf of the appellants. Let's this case on a date when the court hears the matter physically.
Serial number 38 with serial number 39, MA number 327 of 15, with MA number 409 of 15, Mr. Arvind Kumar Awal, as for appellant first case, Mr. DC Ghosh, for appellant in second case, Mr. Vijay Kumar Roy, Mr. Manish Kumar, Mr. PC Sinha, for respondent in first case.
In this case, my lord, I may pray only 1 week adjournment, my lord. Today I am not ready in this case. Only 1 week.
What is this case? You have prayed for enhancements.
Yes, my lord. But I have, because I am not ready, I have not gone through the entire brief, my lord. Therefore, I pray only 1 week adjournment, my lord. Any day after this coming Monday or Tuesday, my lord.
Yes, Mr. Ghosh.
My lord, I am appearing in the next case, 409.
Yes.
Yeah, what challenge?
On which ground?
Only 2-3 small ground, my lord. The in business income has been shown as 10,000, code below taken 6,000. Appellant has challenged that. It may be 5,000 also. One ground. Then the deceased was traveling by motorcycle 8241 as pillion rider. Another motorcycle 1828 dashed the deceased motorcycle. So some sort of contributory negligence case maybe. Of course, I have been saddled with the 100% liability. Third, this future prospect taken 50%. It should be 40%. And interest should be below 9%. 9% has been awarded. This is the ground.
My lords, may I say one thing, my lords?
Yes.
In the first case for enhancement, I think Mr. Ghosh need to appear, my lord, because his name is not appearing. He is the, my lord, saddled with entire liability. My name is also not appearing. Copy has not been served upon me. But at least Mr. DC Ghosh is necessary party, my lords, in the first case also.
Then I will appear, my lord. I will file a
MA 327 of 2015.
Oh, Manish Kumar, your name appeared.
He is my lords with Mr. PC Sinha. There is another Manish Kumar, my lords. His name is there, my lords. In the second case, my lords, you see two names, two Manish Kumars are there, my lords.
But there is Manish Kumar number 1 and 2. ऐसा हो जाना चाहिए.
Mr. Lal, तब कॉपी सर्विस कर दीजिएगा.
हम कर देंगे. किसको? Mr. Manish जी को.
Mr. DC Ghosh, who appears on behalf of United India Insurance Company Limited in MA number 409 of 2015, is requested to seek instruction and appear on behalf of the same insurance company in the connected appeal, which is MA number 327 of 2015. I'll stop. List this case after 2 weeks.
My lord.
Obliged.
Next.
Please, Your Lordship.
Serial number 40, MA number 435 of 50, Ms. Nehala.
Yes, Mr. Alam.
Yes. Kindly see the last order.
Yes.
The insurance company has not complied. Rather, on the other hand, I have filed the affidavit in this connection that within what time the insurance company may destroy the document of policy. Actually,
Yes.
the law is that it has to keep permanently the policy. Permanently means normally a reasonable time, maybe 15, 20 years. But some regulations, my lord, under the act which has been framed, regulations under which they have to maintain policy 8 years. Now I am coming to the fact of the case, my lord. The short fact is this, my lord, that a vehicle, my vehicle, my lord, that is a tanker BPM 3760 was insured with the New India Assurance Company, my lord, in between, my lord, 20/12/1990 to 19/12/91. Date is very relevant, 28th of December 90 to 19 December 1991. Thereafter, my lord, what happened, my lord, it was running on 24/4/92, there was accident after my lord 4 months. Then my lord whatever the documents were in the vehicle, it was stolen away. Vehicle was in accident. Then the police released the vehicle. There was one Wakil Ahmad, namely one Wakil Ahmad died. His wife Amna Khatun filed my lord the MACT case, my lord, that is Annexure 1. My lord, claim case number 26492. Accident claim was allowed. My lord, 1,60,000 with certain percent, 9% interest. It was paid. It was paid by us subsequently. My lord. Then what happened? My lord, it was an
Date of accident, Mr. Alam?
my lord,
Date of accident?
24th April 92.
92. And your previous policy lapsed for 19/12/91.
My lord, I have sent the money, entire check, everything. Money they have received, they have encashed the money. Whether they have issued or not, on this basis, your lordship asked to produce the document. They have taken the ground before the trial court that they destroy the document within 3 years. So they will not produce. So far the claim case is concerned, the insurance company was the party in the first claim case.
Mr. Alokal,
my lord.
What is the mandate? You have to keep the records for how many years?
My lord, I tried to find out, my lord, because of the COVID, some of the officers were suffering from COVID, therefore I could not get it. But the thing is that, my lord, in this case, from the document which is available on record, if my lord may permit, I will refer those documents, your lordship.
Yes.
In this case, what my learned friend is harping upon, because it has gone a series of changes. They have filed a writ application, writ was dismissed, certificate case was filed, and they have filed, then again matter was remanded. After the remand by this honorable court, again the tribunal has given us same finding that there is no policy, because we have taken a stand. Because the policy which was issued to them earlier has lapsed. Now, there is no question of automatic renewal of the policy, because after the renewal, fresh proposal form is to be filled up. Had it been the continuation, now, as per the submission of my learned friend, if it is accepted, 19/12/91 was the policy which earlier lapsed. Still, I do not know whether that was the policy or not. But in this case, the policy which my learned friend is saying that paid premium on 23/12/92/91. So now that cannot be a continuous policy, which has the finding has been given by the London Tribunal in a very specific manner. Yet kindly come to paragraph 10 of the after the remand. May I read it, your lordship? After para 10, in para 10, the Learned Tribunal, after the remand, has very categorically dealt how these policies are being issued. So therefore, and a very significant thing is that, my lord, the bank.
Just a minute. As per Mr. Alam, the previous policy lapsed on 19/12/91. This is admitted.
Yes.
This is admitted. You are admitting this.
My lord, actually, I think I have to recollect your lordship, because last day there were several things. On this basis, there was a detailed argument, and my lord, in the argument we have proved our case that policy even for 91/92 was issued, but it was in my vehicle and it was stolen away. Or my lord, when the accident took place,
I am saying that the policy, there was a policy which lapsed on 19/12/91.
After 90, my lord, when I sent the money, they encashed the money in December 91. My check was encashed, credited in their account. Then
what was the date of the check?
Date of the check, annexure 2, kindly see the annexure 2, page number 44.
Page number 44.
A few days later, 23rd December 91, I sent the check. 23rd December. Page 44. Certificate and the check is on the next 45. Page 45 is the check.
No, what was the earlier policy?
Earlier policy, my lord, that is admitted.
No, I'm not admitting it. I'm not admitting it, that policy.
Page 47, kindly see.
What was the earlier policy?
Earlier policy is admitted, it is admitted that till policy number is there, it is admitted in the document that from 19 to 91, it was admitted. It is
Which date 91? Which date?
date it started from 20th of December 90 to 19 December 91.
So this check is after the validity period of your earlier policy. That means
Yes, after
the
3-4
policy
days.
has lapsed.
After 3-4 days.
So show me the provision of law whether a policy of which has lapsed can be renewed.
Law say that as soon as the check is credited in the account.
Will this be a renewal or a fresh policy?
Renewal. I am
Renewal.
coming.
Renewal.
Even if it is a new policy or renewal policy, whatever the law say, Insurance Act say that insurance starts from the day when the money is credited in their account. And in case, further law say, in case it is cancelled, not admitted, then money has to be refunded and a draft should be prepared. It should be sent to the person to whom, from where it has come. This law say. I have sent the law, section 64 VB of the Insurance Act. I have sent on the page.
You say that a check was issued which was encashed on 30/12/91.
Yes. So from 31st December 91.
What is the check?
Check is below, next page, below. Page 45. And from the back side, can you see the back side of the check?
Yes.
The bank has retained, they did it for renewal of policy. Bank has, because for that purpose, we used to send the check to the bank account. Policy number is also mentioned. It was created in their account. According to me, it was issued, original paper was in the vehicle. It met with accident, fallen in the middle of the deep place. Thereafter, after a few days, we could not find any paper which was within that. Then they say that within 3 years we destroy the paper. Even they did not put the register. They did not put the other any document. Several places they write down the policy. Okay, what is issued and what is not issued. What money has been received. Simply they have denied. And in the first claim tribunal, they have filed a petition for deletion of the name that it is not insured because they normally take the ground that the vehicle is not insured. In all cases, we have been the lawyer of the insurance company for 20 years.
Let us read the judgment. No. Yes. You argue, Mr. Alam.
Start from page number 66.
Yes.
From very beginning, I should read it.
You argue as per your convenience.
Relevant portion.
Argue as per convenience.
My lord, actually my case is this, my lord. Everything in detail has come. My case is this, my lord, that when I sent the check through the bank account, it was duly credited because the bank officials were examined and myself was examined before the court. Everything is proved. But in the rebuttal, the insurance company neither produced a single document nor produced a oral witness, nobody. So their case fails. According to section 102 of the Evidence Act also, if they are unable to produce any document and prove the case by evidence, then they have no case. And I succeeded. And so, according to Insurance Act, that is section VB, 64 VB, which I have sent on the just mail, early hours I have sent.
Sure.
Can you see VB? VB is very important. Section 64 VB, Insurance Act. It is very relevant. This clears my entire case,
64 VB.
VB. V means very, very good. Lordship got it.
Yes.
From the छोटा ही
Yes.
सा order है.
Yes.
No insurer shall assume any risk in India in respect of any insurance business on which premium is not ordinarily payable outside India unless and until the premium payable is received by him or is guaranteed to be paid by such person in such manner and within such time as may be prescribed, or unless and until deposit of such amount as may be prescribed is made in advance in prescribed manner. Next block. For the purpose of this section, in the case of risk for which premium can be ascertained in advance, the risk may be assumed not earlier than the date on which the premium has been paid in cash or by check to the insurer. I am taking a pause, Lordship. Again, I am reading clause 2. For the purpose of this section, in case of risk for which premium can be ascertained in advance, the risk may be assumed not earlier than the date on which the premium has been paid in cash or by check to the insurer. Then explanation. Kindly explanation. Where the premium is tendered by postal money order or check sent by post, the risk may be assumed on the date on which money is or money order is booked or check is posted, as the case may be. जिस दिन चेक डाले उस दिन से इंश्योर माना जाएगा. नेक्स्ट थर्ड, एनी रिफंड ऑफ प्रीमियम, ये रिलेवेंट है. अगर हमारा नहीं करेंगे तो इनको क्या करना है? Any refund of premium which may become due to an insured on account of cancellation of a policy or alteration on its term, because it was altered according to them, in term and condition or otherwise, shall be paid by the insurer directly to the insured by a cross or order check or by postal money order, or proper receipt shall be obtained by the insurer from the insured, and such refund shall in no case be credited to the account of the agent. It is very clear, my lord, that if it is not accepted, my terms altered, cancelled, rejected, then they have to refund back my money. Otherwise, it, according to above mentioned section, clause 2, from the date it is check is issued, it is check is posted, it is insured, my lord. Entire presumption is in my favor. And Evidence Act also 102, my lord, illustration number B, it is very much clear. Then, my lord, order 8 of the CPC is very much clear. When in their rebuttal, the defendant does not produce, then their case failed. I succeed. Because in the trial court, everything has to be, every pleading has to be proved by evidence, either documentary or oral. They have not come with any document, nor come with a oral evidence. I have examined 3 witnesses. All the witnesses proved my case. That check was given, everything, my lord, it should have been insured from, if not 23rd, then 31st of December 1991 till, my lord, 30th of December 1992. Presumed to be, 100% is presumed to be. The Honorable High Court had said in miscellaneous appeal, when subsequently I filed, in writ petition, the court said they pay the money and it will depend upon the result of miscellaneous appeal. Miscellaneous,
who paid the money? Who paid the money?
My lord?
Who paid the money? Who paid the money?
I was directed to pay.
So you paid it?
I paid it with along with interest, and then writ court said that they pay the money and it will depend upon the result of miscellaneous appeal. In miscellaneous appeal order, I have annexed all the order. Miscellaneous appeal, it was said that you go and file miscellaneous case, and if your case is allowed, then your money shall be refunded with 6% interest. Although I have paid 9% interest. So entire case, my lord, if VB it is a law, my lord, beyond law, how can they go? They have not proved their case before the trial court. Without examining witness, either documentary or the lordship last occasion said that we produce the document, they said destroy. Why you have destroyed? How you destroyed? हुजूर हम 20-20 साल का रिकॉर्ड इनके पास देखा है हम लोगों ने. I have been the lawyer. Everything is recorded. रजिस्टर में एक एक चीज नोट है. अगर पॉलिसी नहीं दिखाएंगे तो रजिस्टर में रहता है कि हाँ ये पैसा लिया मैंने, इंश्योरेंस किया या नहीं किया, ये सब डिटेल मेंशन किया रहता है. कोई भी रजिस्टर मंगवा लिया जाए इनका, हुजूर देखा जाए. अभी भी इनके पास होगा. They are concealing the fact.
Where is the first order, first judgment?
Annexure 1.
This is by the claims tribunal.